Welcome back to Canadian Justice. We're discussing a case that went to the Ontario Court of Appeal about whether or not the executive, the premier or cabinet, can refuse to implement laws passed by the legislature, essentially a veto power. Now, Sujit, in this case, Canada Christian College at the Court of Appeal, there were kind of two different issues. There was the issue of whether or not the executive can do this, refuse to bring into force a law that had been passed by the legislature. And then there's the separate issue or of whether or not this particular law should actually be proclaimed into force and Canada Christian College should become certified as a university. Now, we know what happened on one hand. The government conceded that they can't refuse to never bring a law into force. But what happened on the other issue?
Well, the government won, and so what the court said essentially was the following: that the government doesn't have a veto over bringing a law into force, but the government does have discretion, and the discretion has to be exercised in the following way: that the government has to consider from time to time when to bring the law into force, and any reasons for delaying bringing the law into force have to be related to the conditions for the law being effective, or the and the government can't write off the law. And so the court said on the facts that the government didn't have a veto, but it hadn't ruled out or written off the law. It simply said that it wasn't bringing the law into force at this time because certain conditions that needed to be met for the law to be effective weren't being met. And so the government, lost on its assertion of broad executive power, but it won on the facts of the case.
And those conditions were particular standards that a different committee of the government wanted the college to have met in order to just qualify as a university. Is that right?
That's right, and the court said there are conditions that were pertinent, there were conditions necessary for implementing the legislation. And again, this goes to the whole idea about why we have commencement provisions. It's to make sure that the conditions are in place for a law to be implemented properly. And so there's nothing wrong with a government saying, listen, this law can't be implemented properly at this time because certain conditions haven't been met.
Now, on the issue that I'm most concerned with, which is whether or not the government can just straight up refuse to ever implement a law, Paul, if the court had found the other way, that they can, that a government essentially has a veto power, what do you think some of the implications would be if they had decided that?
Well, the implication would be that having legislation passed is no guarantee of achieving your policy objective. That would be a very damaging result for citizens who watch legislation get passed. It would be a very damaging result for the politicians, the backbench MPs and members of legislative assemblies who work so hard to amend and to refine bills as they work their way through the legislative process. To be told that all of your work is for naught because the minister might decide in his or her absolute discretion not to commence a provision at all, that would be very disheartening indeed and would strike a serious blow to the functioning of our democratic system.
Now, Sujit, we've got about a minute left, but we've talked about this Ontario case and we've talked about the Nova Scotia case, where it looks like an indefinite decision never to proclaim legislation. Whereas the Ontario government, they said, well, we might if this college meets these, preconditions. But do you think that the Ontario Court of Appeal decision could have implications for other unproclaimed laws, including the Nova Scotia law that we've been discussing?
I think so, and I think there's two important differences between what we think's happened in Nova Scotia and what we know to have happened in Ontario. So first of all, is that in Nova Scotia, the relevant statute's been unproclaimed for 14 years. In Ontario, this statute was enacted in 2020, so it's 4 years versus 14 years. Uh, the second thing is that in Nova Scotia, in response to the death of another young man at a bar, the government enacted regulations under a different
Mhm.
statute, and so there's this idea in the case that governments can't write
Right.
off a statute that's not been proclaimed. And so the question is, are these regulations an on ramp to bringing the act into
Right.
force, or are they an off ramp?
Really fascinating
And
stuff. Sujit, that's all the time that we've got, but I want to thank both you and Paul for coming on today.